Crime Victim Services is our first witness. And Jen, thank you for hanging in there. We are now live. It is Wednesday, January 31st, and if I'm correct, it's the last day of the year, of the month of January.
Hey, this year flew by.
Yeah, this year flew by. Jen, please go ahead, despite mine.
Thank you. Good morning, Senators. For the record, my name is Jennifer Pullman. I'm the Director of the Center for Crime Victim Services and appreciate the opportunity to weigh in on S209. I wish I could have been there in person, but I kind of dodged a bullet and got home yesterday with driving a car with a hood that wouldn't quite close all the way. So I wasn't brave enough to try that again. So again, my apologies. Today, I'm here to only speak with respect to Section 3 related to the expansion or potential expansion of the Big 12. And the center does support the version that we have, 1.1, and do have two brief comments, specific comments. But before I get to those comments, and again, I plan to be pretty straightforward and brief today. As this committee has discussed, the Big 12, the current Big 12, came out of the concern in reaction to the Hamlin-Savage case. And with a public policy determination, the legislature made that these crimes were serious enough that they warranted enabling a prosecutor to make that decision, have that discretion to either file in criminal or family division. And as we spoke about last year, we recognized that since the Big 12 was established, there were some quote unquote new crimes that were created, and that those were not included. And some of that was addressed when you all added aggravated murder and aggravated sexual assault of a child. But again, part of that discussion last year was focused on the changing landscape that we are seeing in Vermont with respect to youth who are engaged in very serious criminal activity, and some other crimes were considered. And after a great deal of testimony, S4 passed out of the Senate with a proposal that would add 3 additional crimes, which concerned the commission of a felony while carrying a deadly weapon, aggravated stalking, and aggravated and trafficking and aggravated trafficking. What ended up happening, as you know, was the Sentencing Commission was charged with 2 specific questions, addressing 2 specific questions, and then also looking at whether or not to revisit the inclusion of burglary into an occupied dwelling. So we took our charge to mean we were to address whether there should be an expansion, and if so, what crimes would be included. Back in mid-October, a written proposal as requested was submitted by the Department of State's Attorneys and Sheriffs, the Center for Crime Victim Services, and the Department of Public Safety that essentially recommended that we go back to the version that passed S4 with including those 3 specific crimes. As you heard from Attorney Domenica Padula, the AG's office did sign on to that proposal as well. There were no other written proposals offered, and I know you've heard some proposals that came out of that process, but those were actually ones that did not have an opportunity to get fully vetted as they were offered at the end of the process and only offered orally. So it left us in, I felt, a bind in terms of being able to have a robust conversation. I don't agree with my friend, the Defender General, that we always go into our silos. As Senator Sears was on this committee when we did S224, that large juvenile bill, we all came in, everybody, in complete agreement on every provision in that bill. So I do think agreement, I do think consensus is possible, and unfortunately, we did not get here on this particular issue. With respect to the changes in this bill, the center does fully support the changes to the burglary into an occupied dwelling. That one, frankly, for me, has always kind of stood out as a sore thumb, especially as I've learned more about how that has kind of really expanded beyond what its original intent was. So we think that the changes that you are proposing in version 1.1 make an important improvement to this list. With respect to trafficking, again, we can, as last year, we continue to recommend that these cases be added. We certainly absolutely reflect the attempt in version 1.1 to try and make sure that we're not capturing youth who are being trafficked themselves and bringing them into a criminal justice process. Certainly those youth need services and support, but we would really do support the intention behind 1.1 in trying to, thread that needle. We do hear very concerning reports from the field, and there's a piece on your committee page with respect to Katie Newell, who's one of the 2 case managers in Vermont who handle the human trafficking cases. She supervises the she is in the north, and she supervises the person Zoe, who does the south and is based in Bennington. But those 2 people cover the entire state. And what I hear repeatedly from them is that they are seeing ever increasing levels of sophistication, of dangerousness, and orchestration, and how that's overlapping significantly with firearms, gangs, and substances. So they're very concerned and do feel that these cases do warrant inclusion on the list, which is not to say that, again, we don't want to consider how we do those carve-outs, because we certainly don't want to bring trafficked youth into the process. One question I did have about what I see with respect to that attempted carve-out is on page 2. It's subsection, it's 5204A 15 big B, starting on line 15. It relates to the potential that somebody it could be a carve out if an agency, law enforcement, state's attorneys, or the attorney general has made a notification to the victim's compensation program at the center that the person appears to be a victim of human trafficking. And I asked Eric about that, and I understand it's current law. It predates me in my position, but I'm not sure. So I'm not sure what that provision in current law is trying to get at, because as I read this, we don't get those reports if somebody's just observed as a potential victim. We would get this report in the form of an affidavit if the person were in fact a victim of human trafficking, or not in fact, there were probable cause to find that the person was a victim. But we don't just to get a notification that somebody may be a victim. So I think there's a way, if what I think the intention is that there's probable cause that a person has been a victim of trafficking, yes, we would get that. But as this currently reads in statute, I'm not, again, sure that the current language gets us to where I think you're trying to go. So I wanted to flag that piece.
I think it was I'm trying to remember something that's years old, but at the time, I think it was the network. Because the network was going to work with the human trafficking task force, or whatever we called it. I remember doing all the work on human trafficking a few years back, and I think it was the network, but the network was funded through the center, some of the funding, and that's my guess as to how it got there. But I think it's really the network that would be determining and then make a referral to the center that we have a victim.
I think that makes more sense to me, and I can understand that context, because at the time the center did have a large grant from the federal government to put together that trafficking task force, which no longer exists, and there is no grant for that. So I think this language, again, I think that there's a way to get around that and try and work together.
Need to update that language based upon what we're learning now, the grants gone, etc. So, but at the time, I think that was what the legislature had in mind.
Thank you. And I don't have an objection to it. I just don't think it, again, gets you where I believe that this committee wants to go, and where I agree that we should go.
Yeah. Okay. Can you describe aggravated stalking?
Yes, well, and I do want to note there are 5 different elements under 13-1063. And a person commits the crime of aggravated stalking. The person intentionally stalks another person, and there are 5 different ways. Either the conduct violates a court order that prohibits stalking and is in effect at the time of the offense. Subsection 2 has been previously convicted of stalking or aggravated stalking. Subsection 3, which is where this bill is proposing you go, is that the person has been previously convicted of an offense, an element of which involves an act of violence against the same person. So where you focus your potential in terms of a change is really on that subsection 3. So convicted of an offense, an element of which involves an act of violence against the same person. There are 2 other ways that you could be charged with aggravated stalking. The person being stalked is under 16 years of age. And finally, the person had a deadly weapon as defined in section 1021 of this title in his or her possession while engaged in the act of stalking. So I wanted to point out that in this bill, as it's drafted, you have included only subsection 3, which is again that repeated crime on the same person where the initial crime involved violence. I did kind of note that perhaps there might be some way to consider the inclusion of subsection 5, which involved the possession of a deadly weapon, although I understand that with the modifications currently to the firearm usage versus carrying, that might not be as easily included as I would hope. But currently right now, what you're proposing is just, again, that subsection 3.
Senator Baruch, and then Hashim, and then anybody else.
I was a little confused by the language on page 2, subsection B there, when we did it the other day. I'm looking at something different now. It says on line 12, human trafficking or aggravated human trafficking in violation of, unless, and the first one is unless they're a victim of human trafficking. The second one is unless the person reasonably appears to be a victim of human trafficking. And I'm confused by the first way the unless works is unless they are in fact a victim of human trafficking. And the second one is they reasonably appear to be a victim. But I don't know how you can, wouldn't it always be that you were certifying that they reasonably seem to be? Because what would be the fact-finding process there to make sure a person is a victim as opposed to reasonably? In other words, couldn't we just have B and not A?
A requires, Eric Fitzpatrick off the website council, A requires, the way the statute is set up, that the victim actually file a motion with the court.
I see.
And that the court reach a conclusion that the person has been determined.
Okay, so there's a process there where they're found to be a victim.
Exactly.
Under B, you don't have to have that process. It's just a state's attorney or the AG saying, okay,
Exactly.
fair enough.
But we do have to deal with that language that involves the Center for Crime Victim Services.
Yeah.
Because that's, as Jennifer pointed out, is no longer, the grants and LVAD are no longer available. So we might just leave it at the state attorney or the office of attorney general has notified or has determined that the person appears to be a victim. Something like that. I don't know how we
And
do that.
before I pass it to Senator Hashim, I just want to flag number 12 is, Jennifer said it stuck out like a sore thumb before the alteration was made. I don't necessarily think it sticks out like a sore thumb now, but it does seem much less in the scale. So am I right, Eric, that if you had a juvenile who broke into a home with the intention of stealing whatever and didn't know people were there, that they could be prosecuted as an adult if we make this change?
If it was occupied where they weren't aware.
Right, so it turns out that there are people sleeping in the back bedroom and they didn't, I mean, I'm just wondering, because I think what we're trying to do is capture very heinous crimes, and I can imagine a relatively low-level crime where somebody is looking to break into the kitchen and steal food or something like that, and it turns out that there are people there, and then under this, they would be in the company of really heinous criminals in terms of how they're being treated under this expanded BIS 12.
I would say that the scenario you described, yes, that would be covered. And also if they were out grocery shopping and happened to not in the dwelling at the time, but they are currently occupying it, that would also be covered. That's how I read it.
Yeah, because that seems of a different magnitude to me than other, like aggravated sexual assault.
But the problem with breaking in my view, this is just my personal view, the problem with breaking into an occupied dwelling is that it's a very dangerous situation for both the victims who may surprise somebody and then they get stabbed or shot or whatever. And it's also dangerous for the actor who breaks into an occupied dwelling and can easily be shot or whatever. So it was always considered one of those major Big 12 crimes, but it was never intended, in my mind, to cover the hunting camp up at Sucker Pond.
Yeah.
That's only occupied 2 weeks a year.
And to be clear, I'm not saying that someone breaking into your house isn't a serious thing. But if they have a gun, they're covered elsewhere here. But if they don't have a gun, they're unarmed and they break in, do we want to take a 13-year-old and try them in criminal court?
I'll only say, if you remember back, we asked the Sentencing Commission to look at this, and they basically came back with no recommendation.
Yeah.
So we're trying to.
Yeah, I'm saying that one.
I mean, the other choice is taking this one out, having a big board game or whatever.
Just flagging it for discussion.
No, I understand. You're absolutely right. It's not necessarily the nature. As a matter of fact, we even set a carve out during our expungement of records. If you did this crime and you were under 25, you're eligible for expungement.
Mm-hmm.
If you were convicted of breaking into an occupied dwelling. Senator Sheen.
Thank you. Hi, Jennifer. Thanks for testifying. And I agree with you that these are serious crimes. And what I'm trying to understand more of is why, if this is your opinion, why it's more beneficial to have these crimes originate in family court with the opportunity to transfer to criminal court as compared to having them originate in family court with the opportunity to transfer to criminal court.
I think you said the same.
Yeah, you said both.
Originate in family court and then transfer to criminal court compared to originating in criminal,
Right.
Yeah.
with the opportunity to transfer to family. If hopefully I articulated it right the second time.
Okay. I think we got the question.
Great.
Thank you. And obviously, I'm not a practitioner right now in Vermont in this area, but in listening to my colleagues, when I think about aggravated stalking and aggravated human trafficking, I think about victim safety and how can we accomplish that as quickly as possible with as much protections for them as possible. And my understanding from my colleagues is that providing that option, not a mandate, an option for the prosecutor to assess the case, assess the evidence, and assess the potential risk, giving them that option in terms of how to figure out how to best pursue that case is the way to go. And for me, again, it's all about when I think about aggravated stalking, when I think about aggravated human trafficking, is how do we get those protections in place as soon as possible in a very meaningful way. And that's where that's where I'm coming from.
Thank you. And so are they not able to make those assessments in family court if they originate there?
What I understand is that sometimes the criminal process is more adequately, or criminal division is more adequately resourced and has more tools available to more expediently address those issues. But I know that my colleague, Attorney Luders Demont, will be speaking next, and he can better address that.
Thank you. Appreciate it.
Senator Bahowski.
Thank you. From a I recognize your role as, you know, the executive director for Crime Victim Services. Can you think of an instance where a 14-year-old is the mastermind behind human trafficking and not themselves a victim? I just, developmentally speaking, I can't imagine that a 14-year-old has the capacity to not be a victim themselves and mastermind aggravated human trafficking.
No, I cannot imagine a situation like that. And that's why, for one, I think the carve outs are incredibly important. And two, I just would like to say, I know it's not in this current version, but there was no ability to discuss Marshall's proposal around raising the age to 16. But if that would make this bill more palatable, the center doesn't have an objection to, you know, changing the age, the lower threshold for bringing these cases forward. So no, I cannot envision a situation, and my concern would be about getting resources for that young person. We are seeing very serious with older youth that are involved. And so for me, again, that threshold, raising that would not be a problem.
Thank you. I appreciate that.
Okay.
And I would imagine that the resource delivery would be much better suited if these cases originated in the family division, just as they have a different set of resources that aren't based on punishing crime, but are based on resourcing a child or family.
Yeah, what I hear from DCF workers, what I hear from people that work in group homes, what I hear from people that are dealing with these kids is we have a much more dysfunctional, younger population, and probably, only speculate, this is a result of growing up in drug-infested, dysfunctional homes. But we have a population of kids who are really, many out of control. And the difficulty in placing those kids, the difficulty in handling those kids is sky high. And yes, I agree with you. It's hard to envision somebody 14 doing that, but it's difficult for me to envision some of the behaviors I'm hearing about from my former colleagues who work with these kids on a daily basis.
I hear you. And I think that's...
I think we best not minimize the dangers that are out there, and we better get this situation under control in the state and this nation, quite frankly, from the drug, opiate and cocaine and other drugs under control, because we're in trouble. And I don't think we realize this building, we become insulated from some of that, what's going on in the streets, and it's not pretty.
I hear you, Senator Sears, which makes me all the more of the belief we need to invest in resources and not criminalizing kids. I still work in direct service with these kids.
I know you do.
And they need support, help, and resources, and the data supports that charging them through the criminal system is only going to exacerbate the problems we're facing, not help provide the resources needed for them to heal and be functional members of our society. Because I agree with you wholeheartedly, we have to get it under control. I think we just disagree on how to get there.
Anything else for Jen? Jen, thanks so much. I think you're very wise not to drive with the hood up.
Yes.
I had that happen to me once on the highway, and it was probably about 20 years ago, and I don't know how I got over in time, but so now I live in fear, and I notice every little time when, you know, that's not sealed. So I'm just going to stay safe today. Thank you very much.
Last time I had my oil changed, it was a very, very cold day, one of the few this winter, and they didn't close the hood all the way, and I had that little sign, hood's open, and I was worried all the way until I could get into the garage and get it heated up enough to slam it down. All right, Tim.
Thank you, senators.
Thank you. Tim's hood's not up. Successful.
I'm just wearing a mask to be protective of a pregnant wife. No
Understood.
illness here.
Tim Leaders Dumont, the Department of... Thank you very much. I'm nervous and excited.
Nervous and excited.
So roller coaster ride for sure. 10 leaders do at the park, states attorneys and sheriffs. And I'd like to echo everything that my colleague Jennifer Pullman just said as to, her perspective. I often rely on her to sort of bring the full picture, because I know she did spend time in multiple sides to this system, and I know she maybe didn't mention it today, but also working with youth, I think in Massachusetts, and she's told me about some of those experiences as well. Concerning the update to the bill, I wanted to say from the outset, we're very supportive of the work that you've been doing to hone in on this area. You're obviously the policymakers and the lawmakers, and the decisions you make about who's eligible for what, et cetera. We come in and provide hopefully practice or technical assistance, but we certainly appreciate that area is something that we will respond to. However you change things, we'll do our best to respond appropriately. I did speak with legislative counsel briefly before, so he wasn't surprised, but there was a couple comments I wanted to make concerning some of the changes, and upon listening to testimony last time. So on page 2, lines 4 and 5, about the occupied dwelling. Again, this is just it's not a critique of the intent, certainly, which I think is really well intended. But I will say, and I was hesitant to actually say this, I've twice been the victim of a burglarized home in Burlington and in Lincoln. In Lincoln, where I was growing up, there was remnants of firearm activity. We did not happen to be home at the time, but tremendous loss of value, invasion of privacy. I felt like I needed to disclose that just because I have been a victim of crime in particular. We didn't happen to be home at the time, but it did impact me, certainly. And there was I took one day off when I was working for Peter Welsh once in the fall. I took more than one day off when I was working for him, but in the fall one day. And we had a rule not to try to get in the press when you're working for a congressperson. And I went to the New Haven barracks because they had collected a huge amount of stolen property. This is about 12 years ago. And I got in the paper because someone took a photo of me looking to see if any of my belongings were there. And so I broke the rule of not getting into the press. But they said, "What'd you get up to on your day off?" And I didn't know that I had been photographed. But it is obviously a difficult thing. And we often have found that individuals don't know that there isn't someone in the building. Sometimes they might presume, hey, it looks dark, as you said, maybe someone in the back room. But I just wanted to flag to you, because I did get a response from quite a few of our practitioners that it doesn't reflect what the current definition of an occupied dwelling is in the underlying crime. And so what you're doing here is creating a slightly different interpretation just as to the Big 12, which will likely result in litigation, Superior Court interpretation, and potentially Vermont Supreme Court case law as to what this means in this context. Because in the underlying crime, you don't have to prove that someone was there, as you were pointing out.
Yeah, I was just wondering if you can, I think that's interesting. I just am not following quite what you mean by they'll create a different interpretation. I guess my question is ultimately, it doesn't, most of these crimes seem here, this one seems kind of here. Are you saying that they would interpret only the most serious versions of this, or what do you mean exactly?
More from a technical perspective, because the definition of 13 VSA 1201B2 as to this underlying crime, the Big 12 is copy and pasting existing crimes already existing in title. This is a different wording. And so in a currently occupied dwelling, as opposed to in an occupied dwelling, may lead some judges to think about it this way and some to think about it this way. Motions to dismiss, for example.
With language either in intent or language that said for the purposes of this section only, which would be the Big 12, or whatever we end up with. For the purposes of this section only.
That might help. I won't speak for the judges because Judge Zone can do that, but I know any clarity you can provide will help. And
Eric Fitzpatrick, also as counsel, I may be misunderstanding Tim, But I didn't think he was saying that this definition was somehow gonna alter the underlying definition of the substantive crime.
No,
So
no.
I don't think that,
What I'm saying is for the purposes of a Big 12 charge,
yeah,
let's say a judge is reviewing it for probable cause and they find probable cause, but then there's a motion to dismiss by the defense attorney saying, well, a currently occupied dwelling is different than the underlying definition of an occupied dwelling. Therefore, because the individual has done a sworn statement, et cetera, that they had no idea that there was someone in the building, even though there was, it seems ambiguous, and some judges may say, well, they saw there was a light on in the back. Officers said that they did not know it was there. It may create some confusion for Big 12, as Eric said, not for the underlying. You're not altering the underlying piece at all. Just for the Big 12, it may create some ambiguity. And as I said before, people who are victims of these crimes may not feel that this is responsive to their needs because they might be in there and you're having to get into the mind of someone walking in.
Ben, can you check with the Center for Justice Research and see how many charges have been brought in adult court, how many kids have been charged with this as a Big 12 offense?
Because this is the one of the list that seems to me most juvenile. Like, I can see, kids of this age who are admittedly considering a crime and wanting property or money that is not theirs, and they break in to do that. But it seems as though if that's the only thing that they do, admittedly, it's scary if somebody's in there or you feel violated if you weren't in there. But does it deserve to kick them to criminal court as adults, or as though they were adults?
Well, and, my understanding is you could still, if you're a state's attorney, and the case was egregious enough, you could still bring it and, raise it up from family to adult.
You could certainly attempt to, but it may take many.
But I just am curious as how many charges have been brought under the Big 12 offenses.
Yeah, no, it's a really interesting question.
I'm not sure that it's used at all. And if it isn't used much, then we might want to consider removing it. And it's still against the law.
Yeah.
Another side to that coin is that, speaking with some of our state's attorneys this morning before coming in, and I don't have the data to show this because they are confidential family proceedings, but just because something is a Big 12, as Jennifer Pullman mentioned, we are often filing maybe something like this in family court, but there may be a situation that lends itself to a criminal filing. For example, if there's other indicia of violent conduct, for example, firearm.
There's a case that's currently going on that leads a lot of people's concern about the Big 12 and the public nature of the issue with a 14-year-old who is charged with murder in Addison County. Is charged as an adult. And that has led to widespread publicity about him. And then the mother of the victim was in court the other day with T-shirts with the photos of the victim, which is certainly her right to do, and obviously very distraught at what happened. And it all leads to the question of the publicity in this case, which could end up being taken down to the family court, could end up in a YO proceeding. So on one hand, you have people concerned about the victim, as rightfully they should be. On the other hand, I hear from some legislators who are concerned about the publicity of the 14-year-old and what really happened in that car. There were, I think, 4 kids in the car, and the guy was brandishing a firearm. So it's led to some to question whether or not cases should, if you're under 16, if the case should start in juvenile court and then be moved up to avoid that publicity. It's led to some to think that 14 is, the current law is fine. And it's a charging decision of the state's attorney, and they'll do what they'll do. I'm curious as to your views on the suggestion that kids 14 and 15 start in juvenile and can move up, which they currently can anyway for any crime.
I would, as I said at the beginning, however, if you were to change that, we would do our best, certainly, but that's totally in your realm. We currently see more interactions on the upper end of the age bracket, but I would want to talk with the state's attorneys before giving some sort of opinion on that. But it certainly is in your policy realm to figure out what the appropriate ages are. I think you could hear arguments all over the place on that, but I can't represent a unified position today because I haven't posed that specific question.
Back in my earlier days, everything could be, if you were 16 or 17, everything could be an adult or it could be in juvenile. It was all up to the state's attorney. Could be shoplifting, could be adult. Murder could be juvenile. It was all up to the state's attorney. And then at some point we changed the laws and made most, and I think for good reason, that most things start in family court. And if you look at the report from the Justice Lab at Columbia, it shows some good reason for that. But at any rate, I'm working on a guy who's 65 years old now, trying to get his record expunged from Bennington when he was 17, and he actually did a burglary into an occupied dwelling. And he lives in Massachusetts and can't get a hunting license because of this horrible crime that he did 50 years ago. So I'm wondering, that's what's making me pause.
Yeah, no, I appreciate all of the discussion that's happened on this, and I won't be able to comment on the situation in Addison.
No,
yeah, but I did want to flag. So I wanted to just point out that when you're changing, because it leads to my next comment, when you're changing something as to the wording in a Big 12, which is typically a copy and paste of an underlying crime, it may lead to some ambiguity. The next piece was the carrying, carrying a firearm. So the same thing here. Presently, that would cover situations in which someone's carrying a firearm while committing a crime, even if it doesn't end up in use. Whatever use means, the policy rationale is that if a gun is present, it is more likely to be used, and we don't want people carrying guns when they commit crimes. As I said, the change would require that the gun actually be used, it appears. And
no, my intent is absolutely the case in Bennington. The apartment leaseor has allowed these guys to set up shop in her apartment, selling drugs, etc. She's receiving drugs in return for her allowing them to be in shop. She finally says enough is enough, and she wants them out. They set guns onto the coffee table. I think that's a signal.
So that could be used in this.
My intent is that it be used in that definition, that's using, if they're charged with kidnapping at this point, that's using a firearm in the charge of the kidnapping, and they were all under, I think several of them were under 18, or 18 or under. So that's the scenario. They never shot anybody, they never used the gun. They just set it on the they set a number of guns on the coffee table, as a matter of fact. It certainly is a signal.
Yeah, no, I think that if that's
so hopefully whatever we're doing here captures that.
I'm trying to, brandishing, don't we have a crime where if somebody brandishes a weapon or threatens? Criminal threat. Yeah.
I'm not sure we use that term or not.
So just to point out, this is another one where the underlying crime in the code is not using the word using, so it may lead to a Superior Court judge sussing out what you're trying to suss out here, which is what does use mean? Does it mean, as you described, that, or does it mean?
I can only describe my intent in that narrowing from carrying to using. They're not necessarily firing a firearm, they're using it though to intimidate.
Yeah, and just wanted to point it out, and
No.
Eric has my comments, or Attorney Peck has my comments. So, and the last one, just on the human trafficking, I think you guys pretty much discussed everything, but it's, it's a policy call, and the way that we read the immunity piece at the present, just because someone is a victim of human trafficking, if they are also going out and engaging in the activity as a defendant, as the human trafficking, it wouldn't necessarily, under the current law, it wouldn't necessarily shield them. And I don't think that's, yeah.
There's an element of human trafficking, we know it when we see it, but it's hard to prove it. And I've been following what's going on in Watertown and Cambridge, Mass, as well as in the suburbs of Washington, D.C. with a brothel case. I don't know if you've heard of that case. And it's evidently well-connected men, mainly, who have been having, and they're now trying to keep their names out of the press. So that's the main focus. But on the other hand, there's no proof. It looks like the women were shuttled between Mass and Virginia on a regular basis, probably human trafficked, but they haven't even been able to prove that yet. And this has been going on like 6 months now. So I think we may want to revisit this particular crime. And I understand our concern for the victim, but I think it's hard to prove. And what we found, at least in the Bennington case that I can recall, by the time we figured it all out, the victims were probably out of the country.
No, I mean, they're all the
traffic
things that you're working to potentially expand are incredibly serious, which is why we've been in support of them. And the last comment I'll make is just to be consistent with what you did last year, we would recommend, because you made the choice last year, putting attempt at the end of each one of those. Okay. And that was really, the extent of my comments. If you had any questions for me that have arisen over the last couple of
I'm
weeks.
wondering if we're better off just leaving it the human trafficking and not trying to, and just saying if they're a victim of human trafficking or appear to be a victim of human trafficking, that they're not, that wouldn't be a charge. And just leave it at that. But it could take, like I said,
we appreciate the time you dedicated to this session early on.
All right.
Thank you.
Great.
Thank you all.
We're gonna change focus a little bit with Dr. John Lott, who's appearing by remotely from somewhere. He's with
Yeah,
Crime Prevention Research Group, Dr. Lott.
yeah, thank you very much. I greatly appreciate the chance to address the Chair, Senator Sears, and the other members of the committee. I'm from Montana right now, Missoula, Montana. Just to give you a little bit of my background, I was recently Senior Advisor for Research and Statistics in the U.S. Department of Justice. I was previously Chief Economist for the United States Sentencing Commission. And I've had research and teaching positions at the Wharton Business School, Stanford, Yale, University of Chicago, and Rice and UCLA. I'm here to talk about Senate Bill 209. Homemade guns have existed in Vermont and the rest of the country since even before the United States became a country. And it's already a federal crime for somebody to transfer a homemade firearm. The recent push for serial numbers on all parts of guns relies on claims that it protects public safety and prevents violent crime. The current Solicitor General, Elizabeth Prelogar, wrote in a 2023 court filing, quote, "The public safety interests in reversing the flow of ghost guns to dangerous and otherwise prohibited people easily outweighs the minor costs that respondents will incur." Similarly, U.S. Attorney General Merrick Garland claimed in 2022, it will help ensure that law enforcement officers can retrieve the information they need to solve crimes, and it will help reduce the number of untraceable firearms flooding our communities. The expanded use of serial numbers aims at stopping the production of homemade guns, now called ghost guns. While homemade guns have been around since the United States became a country, even before that, it's never been terribly difficult to make a gun with simple machine tools. Their production has become nearly impossible to regulate, however, with the advent of 3D printers. People can just make indistinguishable weapons from those purchased in stores. But even if homemade guns had serial numbers, they don't help solve crimes in the way that you see on TV shows like Law and Order. In theory, if criminals leave registered guns at a crime scene, law enforcement can use serial numbers to trace the weapons back to the perpetrators. But in real life, guns are only left at a scene of a crime when a gunman has been seriously injured or killed, with both the criminal and weapon present at the scene. In a few cases, where the gun's left at the scene and the criminals aren't there, they're usually not registered. And in the couple of cases where they are registered, they're not registered to the person who committed the crime. Police in Hawaii, Illinois, Pennsylvania, Maryland, and New York have had registration systems in place for decades, but can't point to any crimes that this has helped solve. Even entire countries such as Canada haven't had success. In a 2001 lawsuit, the Pennsylvania State Police could not identify any crime solved by their registration system between 1901 and 2001. However, they did claim that it had, quote unquote, assisted in 4 cases for which they could not provide details. In a 2013 deposition for District Columbia v. Heller II, the plaintiffs recorded that the Washington, D.C. police chief could not, quote, recall any specific instances where registration records were used to determine who committed a crime except for possession offenses, end quote. During testimony before the Hawaii State Senate in 2000, Honolulu's police chief said that he could not identify any crimes since 1960 when registration and licensing were started that were able to solve crimes. The police chief also said that his officers devoted about 50,000 hours of their time each year to register and licensing guns yearly. Police time that could have been spent on traditional time testing law enforcement activities. I could go through similar records that exist for Canada. New York and Maryland spent tens of millions of dollars compiling a computer database containing the unique ballistic fingerprints, serial numbers, and names of gun owners for each new gun sold in those states over 15-year periods of time. Even these states, which strongly favor gun control, eventually abolished their systems because they could not point to one single crime that it had solved. Despite predictions by gun control advocates that this program would be important crime-fighting tools, New York scrapped its program in 2012. In 2015, Maryland followed suit. Maryland spent $5 million just on the computerization of the database that was there. New York spent a total of over $45 million on their project. And it was pretty clear from the beginning that these weren't working out well before the 15 years was up. And a 2005 report by the Maryland State Police Forensics Sciences Division labeled the operation, quote, ineffective and expensive. I could go on, but the bottom line is that these policies haven't produced any crime reducing benefits. And I think the main reason why they're pushed is that when you have serialization, it's eventually possible to go and confiscate guns. But I'm happy to take any questions from you, and I appreciate your time.
Excuse me, Senator Baruth.
Thank you, Mr. Lott. So if I'm understanding your argument, you're saying that serialization is expensive and ineffective, as you said. So if we stipulate that, there is another, what I think important piece to this, which is that if a ghost gun is taken in to have a serial number put on it, there's also a background check run. So that's another arm of this, is to try to bring the background check system into focus for these weapons. Do you have an argument about that? Because I don't think you've mentioned it.
Right. No, I did not address that. That's correct. The issue, I guess, would be if the individual has a ghost gun to begin with, and you won't know whether he has a ghost gun or not. You know, is he the type of person then that you're going to be able to use to trace the gun back to him if he uses it in a crime? And I think that is relevant to what I've been saying beforehand. I mean, I suppose if the police are at the person's home and they find that he has the gun, or he's carrying the gun around, and they go and they examine the gun to see whether or not it has a serial number, and it doesn't have one at that point, then they could arrest him for possession of a gun. I think that those are relatively low probability events, but it's still possible, as you say, that could be the case. But in terms of actually solving crimes, I think the arguments that I was making still apply to those.
Well, and I hear what you're saying. Solving crimes is definitely one thing. The other thing is trying to prevent guns from being in the hands of people that shouldn't have them. And so the whole background system is designed to do that. If we have people printing guns in their family room, obviously it's a complete evasion of that system. So this bill has a piece of it that brings that system to bear, understanding what you're saying, that it might be a relatively low probability event that you could stop that person or catch that person committing a crime, but you could certainly catch them with the background system if for other reasons they're not supposed to have a weapon.
But they're not going to, right, I understand. I guess the question is, if it's somebody who's planning on using the gun in the crime, and obviously they don't, or they have a criminal record and they're not going to go through the background check, how are you going to find that they have the gun at home? Are you going to go?
This is the argument that we have over every piece of gun safety legislation, which is that criminals won't abide by it, law-abiding people will, therefore you'll never catch the criminals. But obviously people who put forward the gun safety legislation believe that what we're doing is eventually creating a more law-abiding culture where people abide by the background check system because it catches people who even most gun owners say should not have guns. So that was my question. I appreciate your answers, and I'll turn it over to the others.
Senator Bohowski and Senator Sears.
Wonderful, thank you. I'm wondering if you can explain the peer review process that you use for your data and what process that goes through before it's put out to us or brought to us.
Sure. Well, I mean, I talk about these issues of licensing and registration in my book, More Guns, Less Crime, which was published by the University of Chicago Press. I went through 3 editions, 1998, 2000, and 2010. In each of those editions, the University of Chicago Press sent the book out for peer review, anonymous peer review from other academics. In the 3rd edition, I know they sent it out to 6 different academics to go and do a review of the book. And we had to go through the process where I responded to their comments. They sent it back to the referees. The referees agreed that I had dealt with their concerns, and then the book was published. So that's kind of the normal way that that peer review works on these things.
And so that was more than 20 years ago. Do you have current academic research in academic publications?
Yeah, of course I do. But I'm just saying, I'm giving an example. My book was published, it's not 20 years ago, it was 2010, was the third edition of the book.
Okay.
The examples that I've just gone through in terms of licensing and registration, you know, whether it be, Hawaii or Pennsylvania or some of these other states are more recent. But yeah, no, I've published over 120 articles in peer-reviewed journals. And as I say, I've had academic positions at a wide range of universities. And of course, more recently, as of 2020 and 2021, I was working in the Department of Justice as senior advisor for research and statistics in both the Office of Justice Programs and then the Office of Legal Policy.
Okay, great, thank you. My other question was, so you draw a correlation between the laws in Canada and the lack of evidence for serialization solving crimes, but do you agree that empirically Canada has stricter gun regulations and a significantly lower rate of violence and gun crime?
They had even lower crime rates before they had their gun control laws. So yes, they do have lower crime rates, at least in terms of murder, than the United States, though in terms of other violent crime rates, Canada does have a higher, if you add rapes, aggravated assaults, and robberies, Canada has higher rates of those violent crimes than the United States does, and they had those to begin with. But if you look over time, Canada's violent crime rate as a whole went up after they passed their gun control laws, including
But that is a correlation, that is not causation.
No, but look, there are very few academics that make purely cross-sectional comparisons. What you want to try to do is to look over time to see how crime rates change before and after they have their gun control laws, because there are many other things that can change. And you don't want to look at one place. One of the reasons why most of the world uses US data when they're looking at things is that we have 51 different laboratories. And so hopefully you have enough different states change their laws in enough different years that you can begin to disentangle all the different factors that are there. You can't have more tests. You can't account for more factors than you have tests that you're going to be looking at. But, you know, if you look at my book, More Guns, Less Crime, for example, I look at like 5 different qualitative tests. And while it's possible that somebody may come up with an explanation for one of the tests that are there, you know, that some factor was left out, as you have more and more different types of evidence, it becomes more and more difficult to try to figure out what other factor might be explaining the changes that you're looking at there. The vast majority of academic papers only look at one test that's there, but it's one of the reasons why I look at 5 different types of tests.
Great, thank you.
Thank you, Doctor. I have a couple of questions.
Sure.
But first, I want to describe where I live. I live in the southwest corner of Vermont, very close to Albany, New York. For some reason, the southwest corner of Vermont has seen an increase in police recovering so-called ghost guns, much more so than anywhere else in the state. As a matter of fact, Rutland and Lincoln counties are the 2 highest. And it's inexplicable to me why we would be there. So I was kind of speculating, well, maybe our licensed firearm dealers are doing a better job of stopping straw purchases of firearms, which is forcing the drug cartel, I use that term for real, I mean, they're in business
Right.
to sell here. So my speculation is that maybe the RFSLs are doing a better job than other parts of the state, which is forcing the straw purchases to go away. Is there any basis on that?
Well, I don't know how the drug problem compares across different places in Vermont. I guess my research and training over the years seem to indicate to me how very difficult it is to go and stop drug gangs from getting a hold of weapons. If you stop them in one way, they'll go and find some other way to go and obtain it. Drug gangs have very valuable property that's there. And it's not like they can go and contact the police to go and say, somebody stole our drugs, this other gang stole our drugs, can you help us get them back? They have to essentially set up their own little militaries in order to protect that very valuable property. And you look, if I could click my fingers and cause all guns in the United States to disappear and all illegal drugs, how quickly would illegal drugs start coming back into the United States? My guess is if you live in El Paso, 20 minutes. And how long would it be before they'd bring in weapons to protect that valuable property? I assume they'd be bringing it at the same time. I mean, you can look at a country like Mexico, for example, which has had only one gun store in the country since 1972, run by the military. The most powerful gun that you can legally buy in Mexico is a 22 caliber short round bolt action rifle. That's not the type of gun that drug gangs use down there. Mexico, even though you have less than 1/10 of 1% of the adult population that's legally licensed to own a gun in Mexico, and yet Mexico's murder rate's more than doubled since 1972. And in many recent years, Mexico's murder rate's been as high as 6 times higher than the murder rate that we have here in the United States. And it's not because of ghost guns or anything else that they have there. It's just that they bring in weapons from around the world, literally, just as they bring in the drugs from around the world that they then export to the United States. So, I wish it was a simple problem to go and stop drug gangs from going and getting a hold of illegal guns. But, if you want to go and explain kind of the behavior of drug gangs over time and the amount of violence that they do, it's basically related to changing profitability for selling drugs. As profitability increases at certain points in time, you're going to see more drug gang violence and more efforts to go and get weapons because more is at stake. And so drug gangs will fight against each other, for example, in order to try to control drug turf. It's a difficult problem. You have to figure out ways to take out the profitability for drug gangs there if you're ultimately going to stop them from obtaining weapons in one way or another.
Thank you. Senator Norris and Senator Sheen, and then Senator Bowski, and then we take a break.
All right.
I'm all for a break. Thank you, Dr. Locke, for being here. A couple of things, and maybe I missed it. We were comparing Canada to the United States, so on and so forth. And I don't know if the question was posed in a way of per capita basis, whatever else, but Canada is obviously just shy of 40 million people, and the United States is just shy of 340 million people. So I guess that would make sense that we have more crime in the United States based on population, unless we're looking at it on a per capita basis. But anyways, in reference to serialized firearms, so what I'm hearing is, and I have a second part to this question, I might add. So what I'm hearing is the serialization of guns doesn't prevent crime. The only crime that is incurred upon police responding to this is either a defaced serial number or a firearm doesn't have a serial number on it. Is that correct?
That's right. Yeah, just to answer your first point also, all the discussion that we were having before is on per capita rates of crime.
Thank you.
But that's
and my last question would be, because I don't know the answer to this. I know the kits that are put together and mailed out, whatever, are one thing. The 3D figurations of people putting guns together in their house or whatever else, are those particular guns, do they have rifling in them?
Oh, yeah, sure they can. I mean, you can make a 3D metal printed gun that is functionally and cosmetically identical to any gun that you can go and buy in a store.
So crime is more apt to be solved by ballistics through rifling from a firearm than it is from non-serialization of the firearm.
Yeah, I mean, obviously that's what the FBI does. Obviously, what you do is if you have the bullet at the crime scene, you're not going to have the gun, as you point out. You may arrest the person at some later date for some other type of crime, and if you have confiscate the gun at that time, hopefully you can begin to, link bullets that you have in your inventory with the gun that you may confiscate at the crime scene or from the criminal.
Thank you.
Senator Hashim, would you?
Thanks. Yeah, I guess just a general comment. Yeah, I don't know what's happening in these other police departments where the serial numbers are never being used to resolve crime. I mean, I'm thinking back to 2018, literally one of the final arrests that I ever made was a seizure of a little under, I believe, 10 grand worth of stolen firearms. Serial numbers were essential in resolving that crime. So, and I'm sure plenty of my former colleagues have also used serial numbers in resolving crime. I mean, I'm not going to speak for them, but I'm just speaking on my own experience of from about 5 years ago. That's all.
Awesome, thanks. My question, I just wanted to clarify.
Dr.
Oh, sorry.
Comment on Senator Sheems. Senator Sheems, a former state trooper in Vermont.
Yes, no, I'm familiar with the senator. I appreciate his comment. Well, the question is, what crime are you solving? If the person uses a gun in a crime, and again, we separate out the ballistic issues that Senator Norris was bringing up beforehand. So I catch the criminal, he has drugs on him, let's say, and he has a gun that he's used in some previous crime. The serial number is not going to link you to that crime that the person had committed with the gun. I don't know how it does that. Now, maybe the serial number, you can go then and trace it to see who sold the gun originally to them. But that's different than solving a crime that's there. And what you generally find, even in tracing it back to the original dealer that's there, is not going to, the person probably sold the gun originally legally. So you have a real problem there. It's the serial number is not going to help you solve a crime that the person committed at another point in time with the gun.
I disagree. I solved.
Well, I just logically tell me exactly how. Okay, so I pick up a guy, I pulled him over for a traffic stop. He has a gun. It has a serial number on it. And, 3 months earlier, he shot somebody with the gun. Other than looking at ballistics, how does the serial number there help you solve that earlier crime?
I don't understand your question.
Well, I'm just saying, give me a concrete explanation for how the serial number actually helps you solve earlier crimes that the person committed with the gun.
Sure.
You didn't leave the gun at the crime scene. You don't know that that gun was used at the crime scene.
Me. So you go ahead and finish your statement, but I'm done. So thank you.
Well, I was finished.
Yeah, so I'll finish.
Okay.
The gun that was found in possession of somebody who stole it from somebody else is traced back through the serial number, which proves that the other person reported that gun stolen and had a serial number. Wouldn't that solve the crime? It's not necessarily ballistics.
Right. Where illegal possession of the gun
was used. We don't know if the gun was used in a commission of a shooting, but we know that the gun was stolen. So the serial number proves the gun was stolen because the person reported, let's say the FSL reported these 10 firearms were stolen. These are the serial numbers. Senator Hashim, as Trooper Hashim, finds the 10 firearms. The serial numbers match, proves that this guy stole them.
Right. And when I went through the things, I said possession was the one type of crime that they had been able to solve. And those were, even those were a small number of cases, but for a couple of the places, there were possession type crimes, which is what you're referring to there, that were able to be solved. But there's two different categories. There's actually use of the gun in a crime, and that's like never successful in solving those. And then possession through theft, those it can, but even those are rare.
But I still don't. I'm gonna get into a real problem here by saying something that I probably shouldn't say, but I still don't understand why people are opposing this bill. I think this is the simplest bill I've ever introduced in terms of anything to do with firearms, much simpler than red flag laws and others. And I know I get in trouble for that, but good Lord. If I can print this, if I can print up a firearm and nobody can trace the serial number, it makes it much more difficult. So I don't understand what the problem is. But anyway, Senator Wachowski.
Yeah, I just wanted to clarify, because my brain was processing all the information earlier. Was your testimony that rapes are higher in Canada than in the United States?
Homicide rates are lower, much lower in Canada, but overall violent crime rates are higher in Canada. If you look at the International Crime Victimization Survey, the overall violent crime rate in Canada is about 50% higher than the overall violent crime rate in the United States. So that's going to be rape, robbery, and aggravated assaults.
Because I'm looking at international data that shows that the rape rate in Canada is in fact 23 times lower than in the United States. So I guess we're back to our data issue, that the data seems to be kind of all over the place. So thank you for clarifying that for me.
Okay, are there any other?
No, I'm good.
You're done.
Yes.
You're done. You're done. I'm done. Dr. Lott, thank you so much for joining us this morning. You're in Montana today.
Right.
Is that correct?
Yes, correct, sir.
Well, thank you for joining us early then. We
All right.
recognize there's a time difference in Montana, and hopefully you get to see the sun. We haven't seen the sun in eight days. Come on. So
Well,
hopefully you get to see the sun today.
Yeah, it's supposed to be up into the 50s today and clear. So, but anyway, I greatly appreciate your time. Thank you very much.
Thank you, Doctor. Bye now. So we're going to take